So we've been looking into this real quirk in the penal code today. It almost feels like a legal paradox.
It really does.
Our whole mission here is to figure out why the law sometimes prioritizes family peace over, your actual property rights.
Exactly.
Imagine this. Someone steals your watch, or maybe they swindle you out of some savings. But the police say they can't prosecute. Why? Because the person is your mother.
It sounds unbelievable, but it's grounded in a very specific law. Article 332 of the Revised Penal Code.
Article 332.
It creates what some of the sources call a protected zone. The state is basically deciding that for certain property crimes, it's more important to preserve the family.
So they're saying, we're not going to be the ones to put your spouse in jail over a stolen ring.
Pretty much, but that nonviolent part you mentioned is, it's the most important detail.
Right. This is not a free pass for everything. The research is clear. This immunity only covers three things: theft, swindling, or estafa as it's called, and malicious mischief. If there's violence, if there's any kind of intimidation, this entire protection just disappears.
It's gone. The law might overlook a family's squabble over property, but not a physical threat. Never.
And can we just clarify malicious mischief? It sounds so old-fashioned.
It does, a bit Victorian. It's basically the legal term for when someone intentionally damages your property just to be spiteful.
So, like, your brother gets mad and smashes your laptop screen.
That's a perfect example. Under Article 332, he's shielded from criminal charges for that act.
Okay, so who exactly is inside this protected zone?
Well, the direct line is pretty broad. It starts with spouses, and importantly, that now includes common law partners.
That's a very modern inclusion.
It is. Then you have ascendants and descendants, so parents, grandparents, children, grandchildren.
And what I found fascinating is that it doesn't matter if it's biological or not.
No, not at all. Step-parents, adopted children, they're all treated exactly the same. The goal is to protect the peace of the household, however that household is formed.
But it gets stricter once you move outside that direct family line.
It gets much stricter. That's where you find the living together rule.
Right. So for brothers, sisters, brothers-in-law, sisters-in-law, they only get this protection if they're living with you when it happens, which feels a little strange. So if my sister lives across town and steals from me, she could be charged. But if she's sleeping on my couch for the month, it's just a family matter.
That is precisely the logic. The law assumes that sharing a roof means you share a life, and the state is even more hesitant to step into that space.
Living apart makes the family harmony argument weaker in the eyes of the court.
Exactly. It's seen as a separate household, and so it's fair game for prosecution.
Okay, but here's where it gets even weirder for me. The stranger factor.
Ah, yes. This is a key point.
So let's say my brother, who lives with me, steals my laptop, but he gets his best friend to help him carry it out.
Okay.
Under the law, my brother is exempt, but his friend...
The friend faces the full criminal charges. The exemption is personal. It doesn't, rub off on accomplices.
That's just wild. Two people do the exact same thing, but only one is legally a criminal.
It shows the law isn't protecting the act. It's protecting the relationship. It's acknowledging some family bonds are too delicate for the criminal system.
But, and this is a huge but, I want to be sure everyone understands this. Exempt from criminal liability does not mean they just get away with it.
Absolutely not. This is probably the biggest misconception.
The sources are crystal clear on this. You are still civilly liable. So while the state won't give your relative a criminal record for the theft...
You could still sue them. You could take them to civil court to get your property back or to get paid for the damages.
So the state basically says, we won't break up your family with a jail sentence, but you still have to pay your dad back for that car you borrowed and wrecked.
That's the balance it tries to strike. The shield is there, but the debt isn't erased.
It's a lot to wrap your head around, how the law draws these lines. So we've seen this pass is granted to keep family out of jail and preserve the unit. But here's something to think about. Does requiring siblings to live together to get this protection still make sense? In a world where families are scattered but maybe more connected than ever, is sharing a roof still the best measure of a relationship worth protecting? Something to mull over.
Ever heard of a crime that's, well, not a crime, as long as you commit it against your own family? Sounds like something out of a movie, right? But it's a real legal principle, and we're gonna unpack it today. So, let's just cut straight to the chase. Can you steal from your family and actually get away with it, legally speaking? I mean, in most parts of the world, that would be a hard, definite no. But in the Philippines, the law has a pretty surprising twist. We're about to explore a legal exemption that might just make you rethink everything you thought you knew about crime, justice, and family. So let's get into it. Our journey begins with a specific article in the Philippine Criminal Code. It creates what's known in legal speak as an absolutory cause, which is essentially a get-out-of-jail-free card for certain family crimes. This right here is the heart of it all, Article 332 of the Revised Penal Code. It flat out says that if you commit certain property crimes against a close family member, you are exempt from criminal charges. And this isn't some kind of legal loophole, it's a very intentional part of the law. So why on earth does this law even exist? It's a fascinating trade-off, really. The law basically says it's better to keep family disputes private than to air all that dirty laundry in a messy public trial. It's all about trying to preserve family harmony, even if it means some crimes go unpunished. So, who gets this special treatment? The law is extremely specific about which family members are included in this, let's call it, circle of trust. Okay, let's break it down. You've got the usuals, spouses, and yes, that includes common law partners. You've got ascendants, that's your parents, grandparents, and descendants, so children and grandchildren. Even relatives by affinity, like step-parents. But look at this last one, because it's key. Brothers, sisters, and in-laws are only covered if they are living together. That little detail makes a massive difference. Let's see how this plays out in a real case. A stepfather, in a fit of rage, destroyed his stepson's suitcase. Because a stepfather is considered an ascendant, the court let him off the hook for the crime of malicious mischief. It's a pretty wild example of this law in action. And it doesn't stop there. In another case, a brother-in-law misused some money. The key to his whole defense, he was living with the family he wronged. That living together clause was what saved him from criminal charges. But this family pardon doesn't cover everything. The law is very, very specific about which crimes actually get a pass. All right, here's the lineup. On one side, you have the crimes that are covered. Things like theft, swindling, and property damage. You can think of them as the non-violent offenses. But on the other side, you've got the deal breakers. Robbery, forgery, and arson. These are the ones that cross a line. So what's the magic ingredient that separates these two lists? Well, it all comes down to violence or intimidation. The moment you use force or threaten someone, the family pardon just disappears. So snatching your dad's wallet from his desk might be covered, but threatening him for it? That's a one-way ticket to a robbery charge. Now, before you get any crazy ideas, this family pardon is not a free-for-all. There are some really serious limitations you need to know about. Okay, here's the biggest catch of all. This law only protects you from criminal charges. You can't be prosecuted and thrown in jail, but you can still be sued in civil court. So you might not do time, but you'll still have to pay up for whatever you took or broke. And there's another major catch. The family pardon is like a members-only club. The moment an outsider gets involved, the rules completely change. Here's how that works. Let's say a son steals money from his dad. The son is exempt under Article 332. But if his buddy helps him commit the theft, that friend is going to face the full force of the law. The family pardon protects the family member, but it definitely will not save your friends. So what does this all add up to? Well, it's a law that puts two of our most cherished values, justice and family, on a direct collision course. Here's the bottom line. Article 332 is a bold statement. It's the government basically saying we're going to trust families to sort out their own problems, even if that means some crimes go officially unpunished. It's a risky bet on the power of family to heal its own wounds. So what's the verdict? Is this a smart way to protect families, or is it a dangerous loophole that lets people get away with crime? It's a tough question, and there are no easy answers. What do you think? Where should we draw the line between justice and family?
I want you to close your eyes for a second. Picture this. It is a Tuesday night. You've just come home from a grueling day at the office, maybe 10, 11 hours.
Yeah.
You are exhausted.
We've all been there.
Totally. You walk into your living room, you drop your keys in that little bowl by the door, and you see your stepfather standing there.
Yeah.
And he is not happy.
Oh, boy. That is never a good start to a story.
No, it's not. He's absolutely furious. Maybe you forgot to mow the lawn. Maybe you left the gate open. It doesn't even matter. The red mist has descended.
Mm-hmm.
He walks over to the corner of the room, grabs your suitcase, and let's say it's a really nice one, vintage leather. Maybe you have your laptop inside, some expensive clothes, and he drags it out the back door.
Oof. I can just hear the scraping of the leather on the pavement.
Exactly. He drags it all the way out to the orchard in the back of the property. He throws it onto a pile of dry leaves, pulls out a lighter, and he sets it on fire.
Wow.
You're standing there at the window just watching your property, your hard-earned stuff, literally turn into smoke and ash.
That is such a visceral image. It's violent, it's destructive, and frankly, it's terrifying.
Right. So naturally, your brain immediately goes to the justice setting. You think, okay, put out the fire and then I'm calling the police.
Of course.
You think this man is dangerous. He destroyed my property. That is a crime. He is going to jail.
Which is the logical, rational response
Right.
in, what, 99% of scenarios? If someone burns your stuff, they are looking at handcuffs, a booking photo, and a potential prison sentence.
But, and this is why we are here today, this isn't the 99% of scenarios. This is a very specific, very weird corner of the legal universe. We've been digging through a stack of legal documents, specifically looking at Chapter 10 of the syllabus on crimes against property. And we're focusing on Article 332 of the Revised Penal Code. And if I am reading this right, there's a very, very good chance that your stepfather walks away.
Walks away from criminal charges. Yes, absolutely.
No jail.
No jail.
No criminal record from this.
No criminal record.
That sounds insane. It sounds like a glitch in the simulation. I mean, surely arson and destruction of property are crimes, regardless of who does it.
You would think so. But what you're describing isn't a glitch, and it's definitely not an oversight. It's a feature. It is a deliberately designed mechanism in the legal system called the family exemption.
The family exemption.
And honestly, when you first read it, it feels like it breaks every single rule of fairness we've ever been taught.
Well, that's exactly what we're going to unpack today. This is the deep dive into Article 332. Our mission is to figure out why the law effectively says that if you steal from, swindle, or destroy the property of your own family, it's not technically a crime, or at least not a crime the state cares enough to punish.
And we need to be really careful with our terms right at the gate, though. It is a crime. The act itself is illegal, but the liability, the punishment, that's where the magic trick happens. We're going to explore who holds this get-out-of-jail-free card, who gets left out in the cold, and why on earth the legal system decided that, in some cases, family privacy is more important than punishing theft or malicious mischief.
I am still stuck on the burning suitcase. I really am. Because if a stranger did that, they're done. They're finished.
Yeah.
But because he married my mom, he gets a pass.
In a manner of speaking, yes. But it's a very nuanced.
It better be nuanced, because otherwise I'm worried about everyone's safety at family gatherings.
Yeah.
So let's start at the very beginning of the source material. We've got Article 332. What is the headline, the big, bold text at the top?
The headline is Exemption from Criminal Liability. That's the core concept. But immediately, and I mean in the very first bullet point of the source text, there is a massive disclaimer, a huge wait a minute sign.
Okay, which is?
It says, quote, exemption from criminal liability does not carry with it exemption from civil liability.
Okay, stop. We hear civil and criminal thrown around in legal dramas all the time. You know, Law and Order, Suits, whatever.
Yeah.
But I feel like most people, myself included, kind of treat them as interchangeable bad things that happen in court.
Yeah, that's common, but they are definitely not interchangeable. They are two completely different legal universes with different goals.
So break it down for us. If Article 332 exempts me from criminal but not civil, what is actually happening to me? What does that mean in the real world?
Let's look at the philosophy first. Criminal liability is the state versus you.
Right. The people of the Philippines versus John Doe.
Exactly. When you commit a crime, let's say robbery, the state says, you have broken the social contract. You are a danger to the peace and order of society. Therefore, we, the people, are going to punish you.
Right. And that's the district attorney, the prosecutor. The goal is punishment.
The goal is retribution, rehabilitation, or, just getting you off the streets. The result is prison time, a permanent criminal record, the loss of certain rights. It's the state wielding its sword. Article 332 essentially puts a sheath on that sword. It says, in this specific family context, the state is stepping back. We are not going to put you in an orange jumpsuit for this.
Okay, so the police aren't coming to drag you away from the dinner table.
Correct. But then you have civil liability. This is entirely different. Civil liability isn't about the state. It's about the victim. It's not about punishment. It's about restoration.
Restoration.
Making things right. If I break your window, criminal law says, go to jail for breaking the peace. Civil law says, pay for the window. It's about the money.
So in the case of our burning suitcase,
In the case of the burning suitcase, if the exemption applies, the state won't send the stepfather to prison. That's the criminal part. But the stepson can sue him in civil court. He can stand before a judge and say, he owes me $500 for that vintage leather suitcase and another $1,000 for the laptop that was inside.
and the judge can actually order him to pay.
Yes. The court can order a restitution. They can say, you must pay this amount. And if he refuses, they can garnish his wages, they can seize his assets, they can put a lien on his property. He is still legally obligated to make the victim whole.
Okay, but let's be real for a second. That sounds great on paper, restitution. But practically, if my brother steals my life savings and the state says, sorry, can't help you, my only option is to sue him.
That is your only legal option,
It
yes.
seems, I don't know, weak. I mean, suing someone is expensive. You have to hire a lawyer, you have to pay filing fees, you have to wait for a court date. It could take years.
It can. It's a long process.
You know, what if my brother's a deadbeat who already spent all the money on gambling or whatever? What am I going to get? A piece of paper, a judgment saying he owes me $1 million that he doesn't have.
You have hit the nail on the head. That is the fundamental criticism of this exemption. Civil liability relies on the offender having assets to seize. If they're broke, you get nothing.
Right.
Criminal liability, on the other hand, has the threat of prison, pay me back, or go to bill a bid. That is some serious leverage. Article 332 takes away that leverage.
So why do it? Why would the law deliberately take away the only real stick the victim has to beat the offender with?
Well,
What's the rationale?
Well, it comes down to a specific legal philosophy about the family. The source material implies that these are viewed as private domestic disputes. The state effectively says, we do not want to use taxpayer money and court time to referee a fight between a husband and wife over who owns the TV.
They want to stay out of it.
They want to stay out of it. You two sort it out. If you need a judge to look at the receipts and decide who pays, fine. But we are not sending the police to drag a father away from his children over a property dispute.
It's the whole sanctity of the family argument.
Exactly. The belief, or at least the theory, is that criminal prosecution, prison, handcuffs, mugshots is a nuclear bomb. If you drop that bomb on a family, you destroy the family unit forever.
Right. There's no coming back from sending your dad to prison.
Almost never. But if you just sue him, maybe, just maybe, there's a path to reconciliation later on. It's about preserving the family unit, even a dysfunctional one, from the destructive power of the state.
I see the logic. Don't burn the house down to kill a rat. But it still feels like it leaves the victim incredibly vulnerable, especially if the offender is manipulative or abusive.
It does. It absolutely places the burden on the family to police itself. It makes an assumption of a level of functionality that might just not exist in that family. But that is the law as it stands.
Okay, so we've established the mechanism. No prison, yes payment. Now we need to figure out who has this VIP pass to the no jail club. Is it just anyone with the same last name? Can I rob my cousin? Can I swindle my aunt?
No, absolutely not. The source material is incredibly strict and specific about the who. It is not a free-for-all. It is limited to 3 very specific circles of people.
Like circles.
Right, and if you fall outside these circles, Article 332 offers you 0 protection, and you are facing full criminal prosecution like any other stranger.
All right, let's meet the lucky contestants. Who is in circle number 1, the inner circle?
Circle number 1 is the most absolute, the most intimate bond. Spouses.
Husbands and wives. That
Yeah.
seems the most obvious, what's mine is yours, all that.
Right. But the source material, right away, throws us a fascinating curveball here. It cites a case, People versus Constantino, and it explicitly expands the definition of spouse.
Expands it how?
It includes concubine or paramour.
Whoa, okay. Concubine is a very Old Testament word, and paramour sounds like something out of a romance novel. We're talking about, what? Mistresses, live-in boyfriends, common law partners.
Yes, all of the above. The source notes that the exemption applies to a concubine or paramour regarding the property of the other, so your live-in partner.
That feels, I don't know, surprisingly progressive, or maybe just cynical. Why would the law give a concubine the same legal protection from theft charges as a legally married wife? Usually the law loves that marriage certificate.
Well, it's actually rooted in economics, not morality. The source explains the reasoning used in the People versus Constantino case. The court argued that when 2 people live together as husband and wife, even without the piece of paper, they are essentially co-owners of the property they acquired during that time through their work or industry.
Co-owners. So if we're living together and I buy a toaster with my salary, and you buy the blender with your salary, the law sees it all as ours.
In the context of criminal law, for this purpose, yes. Think about the legal definition of theft. Theft is taking the property of another.
Right.
If the law views you as a co-owner, you cannot technically steal from the partnership. You can't steal what is already, in part, yours.
So if a common law wife takes cash from the common law husband's wallet, the law doesn't see thief taking victim's money. It sees partner, moving partnership funds from one place to another.
Precisely. It becomes a dispute about the administration of the partnership, not a crime against property. It might be a misappropriation, something to be sorted out civilly, but it's not theft.
That is fascinating. It basically validates the relationship as an economic unit, regardless of what the church or the civil registrar has to say about it.
It does. It acknowledges the reality of domestic life for millions of people. When you live with someone that intimately, finances blend, property blends, trying to untangle that in a criminal court is messy and, the law argues, destructive and unnecessary.
Okay, so spouses and partners are covered. Total exemption. Who is in circle number 2?
This is the vertical line. Ascendants and descendants.
Parents, grandparents, great-grandparents, and then children, grandchildren, and so on.
Correct. The direct bloodline, up and down. You cannot be criminally liable for these specific property crimes against your parents or your children.
Got it.
But we have to go right back to your burning suitcase story, because this is where that definition gets tested in a really interesting way.
The stepfather.
The stepfather. The source cites People versus Alvarez. This is the case that directly addresses your scenario. It's almost like you read it.
So walk us through the Alvarez case. What actually happened?
Well, in People versus Alvarez, a stepfather was, for reasons not fully detailed in our notes, incredibly angry with his stepson.
Okay.
In a fit of rage, he took the stepson's suitcase, which contained his personal effects, dragged it out to an orchard, and set it on fire.
Okay, so it's literally my nightmare scenario. It really happened.
It really happened. Now, the stepson, rightfully upset, went to the authorities. He wanted the stepfather charged. The charge that was brought was malicious mischief, which is basically the legal term for intentionally damaging someone else's property.
And the court said?
The court said, not criminally liable, acquitted.
I really struggle with that. The guy is a stepfather. He isn't the biological dad. He has no blood relation. Why does he get the dad pass?
The source material points to the legal concept of affinity.
Affinity?
Yes, the law covers relatives by affinity in the same line. When you marry someone, their direct line relatives become your relatives by affinity. Their mother becomes your mother-in-law, and their children become your children in the eyes of this statute. The stepfather stands in the shoes of the father.
So the law is essentially forcing a one big happy family framework on a situation that is clearly not happy at all.
It is, for the purposes of this exemption. It's assuming that the bond of marriage creates a single, unified family unit that is just as sacred as the biological one. The law is reluctant to create a two-tier system of family where step-parents are treated as lesser parents than biological ones. So Article 332 refuses to do that. It treats the stepdad exactly like the biodad.
I guess I can respect the consistency even if the outcome feels gross in the specific case. It basically tells the stepson, look, he's your legal father for this purpose. Deal with it civilly. Sue him for the money, but don't expect us to put him in jail.
That's exactly it. And just to be clear, the source also clarifies the other direction of this. It explicitly includes adopted or natural child.
Right, so if I adopt a kid and 5 years later he gets into some trouble and steals my car.
He is exempt. He is your son. There is absolutely no distinction between biology and adoption in this context.
You know, that I like. That feels right. If you sign the adoption papers, you are the parent, period. The bond is total.
Agreed. It solidifies that legal bond and prevents any kind of discrimination.
Okay, now before we move on to the third and final group, I need to ask you about something in the Alvarez notes. There was a little asterisk there, a note about arson.
Ah, yes. The arson asterisk. This is a critical technicality. If you are listening to this and thinking, great, so the law says I can burn my stepson's stuff, please stop.
Put down the lighter and the gasoline.
Please. In the Alvarez case, the charge was malicious mischief. That is the key. Malicious mischief is one of the exempt crimes listed in Article 332. However, the source notes that under a later law, Presidential Decree number 1613, we have a very specific and serious law for arson.
And arson is defined as?
Simply burning the property of another.
So wait, if that same act from Alvarez happened today, or if the prosecutor back then was just a little bit sharper?
If the prosecutor had charged it as arson instead of malicious mischief, the exemption might not have applied. Arson is not on the list of exempt crimes in Article 332.
Why the difference? Why is damaging a suitcase with a hammer exempt, but burning a suitcase might not be? It's the same result, a destroyed suitcase.
It's about the method. It's about the danger. Malicious mischief, smashing it, cutting it with scissors, spray painting it. That's a private dispute over property. But fire is different.
How so?
Fire spreads, fire is uncontrollable, fire puts the neighbors at risk, it puts the whole community at risk.
Right.
Yeah.
You light a suitcase on fire in a dry orchard, a stray wind blows, and suddenly the whole block is up in flames.
Exactly. The moment you use fire as your weapon of destruction, the crime stops being just about family property and starts being about public safety. And Article 332 does not, and was never intended to, protect you from crimes against public safety.
So the stepfather in Alvarez, he essentially got lucky. He got lucky that he was charged with the lesser private crime of mischief and not the public danger crime of arson.
He threaded a very, very thin legal needle, yes, whether he knew it or not.
That is a terrifying distinction. It means the difference between freedom and a lengthy prison sentence could come down to whether you used a knife or a match.
Welcome to the beautiful and terrifying nuance of criminal law. The specific charge is everything.
Okay, let's move to circle number 3. This is the one that feels the most conditional, the most specific. We've done spouses, we've done parents, kids. Who is left?
Widows and siblings, but both come with big if clauses.
Let's start with the widows. I'm a little confused. I thought spouses were already covered in circle 1. Why is there a separate rule for widows and widowers?
Because when a spouse dies, the legal status of all their property changes. It ceases to be marital property and becomes an estate.
Oh, okay.
So the source mentions a specific exemption for a widowed spouse with respect to property which belonged to the deceased spouse.
Okay, so husband dies. In her grief, the wife takes his expensive watch, which he had promised to his brother. She's exempt.
Yes. But here's the huge condition attached. The source says the exemption only applies before the same passed into the possession of another.
Break that down for me. Passed into the possession of another. What does that mean?
Let's use your watch example. The husband dies. He leaves a will giving that watch to his brother.
Okay.
In those first few days or weeks immediately following the death, in that chaos of grief and sorting things out, if the widow takes the watch and keeps it, she's exempt. It's seen as part of that messy transitional period.
Got it.
However, if the executor of the estate comes in, does the inventory, takes the watch, catalogs it, and formally hands it over to the brother, and then the widow goes to the brother's house and steals it back.
The shield is down.
The shield is completely down. Once a third party, someone outside that immediate marital bond, has taken valid legal possession, the exemption vanishes. The watch is no longer property of the deceased spouse. It is now property of the brother.
So it's like a grace period. The law acknowledges that death is messy and possession is blurry right after a funeral, but once the dust settles and the property officially moves on, special rules end.
Correct. It prevents the criminal courts from having to act as probate courts during that immediate grieving period, but only up to a point.
Okay, that makes sense. Now for the siblings, this is the one that I think will surprise people the most. I have a brother. If I steal from him, am I exempt?
It depends entirely, 100% on your living situation.
My living situation, what does my address have to do with it?
Everything. The source states that for brothers, sisters, and even brothers-in-law and sisters-in-law, the exemption applies only if they are living together.
The roommate rule.
The roommate rule, exactly. The source brings up a case for this one too. People versus Navas.
All right, tell us about Navas. What happened there?
So in this case, we have a brother-in-law. He was given some money by his sister-in-law that was supposed to be used to buy plumbing fixtures for a project.
Plumbing fixtures. Okay.
Yeah.
Very specific real-world stuff.
Real cases are always specific, so he takes the money.
Yeah.
But instead of going to the hardware store and buying the pipes and faucets, he just keeps it. He misappropriates it for his own use.
That's a classic estafa. Swindling,
Oh.
deceit.
Normally, yes. That would be a textbook case. But, and here's the kicker, at the time of the crime, the accused brother-in-law was living in the house of the offended party, his sister-in-law.
He was part of the household. He lived there.
He was. And because of that shared address, the court ruled he was exempt from criminal liability.
Wait a minute. So if he had been living in his own apartment across town, and he did the exact same thing, took the money, promised to buy pipes, and then kept it, he would be a criminal.
Yes, without question. He would be liable for full criminal prosecution.
It seems so arbitrary. Why does geography change the morality of the theft? The act is identical.
It goes back to that economic unit concept we talked about with the concubines. The law makes a presumption. When siblings or in-laws live under one roof, resources commingle. Who bought the milk? Who paid the electric bill this month? Who owns the cash sitting on the kitchen counter? It's all a big, messy, domestic pool of resources.
What's mine is yours again, but only if we share a mailbox.
That's a perfect way to put it. In a shared household, the law presumes that property disputes are domestic misunderstandings that should be handled civilly. But once you move out, once you have your own house, your own bills, your own separate economy, you are now strangers in the eyes of property law.
So if I go over to my brother's house, where I don't live, and I take his TV while he's at work, that's an invasion of his separate home.
That is theft, a clear-cut invasion of a separate, sovereign household. You're a stranger crossing a boundary.
But if I'm living in his guest room for the summer and I take the TV and sell it?
That is a roommate dispute, civil liability only. The law sees it as an internal household matter.
That is just wild. It really puts a premium on the roof. The roof is the legal boundary of the exemption.
It is. And notice it includes brothers and sisters-in-law. So that brother-in-law who's been crashing on your couch for 6 months, he has legal protections that your other, more responsible brother-in-law living down the street does not have.
Note to self, check the guest room for any missing items.
Always check the guest room.
So we have the WHO fully mapped out. Spouses and partners, ascendants and descendants, including steps and adopted, and the very conditional group of widows and roommate siblings. Now, we need to clarify that we touched on arson, but let's be really specific. Which crimes actually get this family pass?
The source lists the 3, and only 3. Theft, swindling, which is also known as estafa, and malicious mischief.
Okay, so theft is taking, swindling is tricking, and mischief is breaking.
Broadly, yes. These are the classic nonviolent crimes against property.
But looking at the source, there's a very important list of exclusions, the no-go zone, and the biggest one on that list is robbery.
Yes, this is a distinction that trips people up constantly. In everyday language, we use robbery and theft almost interchangeably. In the penal code, they are night and day.
Explain the legal difference for us.
Theft is stealth. Theft is taking something without the owner's consent, but without violence or intimidation. Pickpocketing is theft. Shoplifting is theft. Taking a wallet off a dresser while your dad is asleep is theft.
Okay, and robbery.
Robbery requires violence or intimidation against a person. It's not just about taking property. It's about using force or fear to do it.
So if I walk into my dad's room, hold a knife to his throat, and say, "Give me your wallet,"
that is robbery. And Article 332 offers you 0 protection, not an ounce.
because violence entered the chat.
Exactly. The moment you threaten a person, the moment you use force, the law says, okay, this is no longer a private family squabble about money. This is a violent crime. The exemption evaporates immediately. The sanctity of the person is always more important than the sanctity of the family unit.
That is a relief, honestly.
Yeah.
I was worried for a second this might cover domestic violence situations where property is also taken.
No, absolutely not. Violence against the person is never, ever covered by Article 332.
Okay, good. What else is excluded? The source mentions something about falsification.
Estafa through falsification of a public, official, or commercial document. This is a tricky one.
So simple estafa, just lying to your sister to get money, is exempt if you live together.
Correct. But if you commit estafa by, say, falsifying a public document,
Like what? Give me an example.
like forging your mother's signature on a deed of sale to sell her land, or faking a government ID to empty her bank account, altering a court document to claim an inheritance.
Why is that different? You're still just swindling your mom.
Because you aren't just hurting your family member anymore, you are now attacking the public trust. You are messing with the integrity of the public record system. The state has a vested interest in protecting the reliability of its documents.
Ah, I see.
So they don't let you off the hook just because you used the fake document to scam your own mom. The crime has a second victim, the state itself.
That makes sense. The victim is the family plus the state, so the family exemption can't cover the whole crime.
Precisely.
Okay, I want to pitch one final scenario to you. This comes from the stranger exception in our notes, and I think it's the most movie plot, most mind-bending aspect of this whole law.
I love this part. It's the heist clause. It really shows how personal the exemption is.
So let's set the scene. I want to steal from my wealthy father. I am the son, so I know I'm exempt under Article 332.
Right. You're living at home. You have the shield.
But I can't do it alone. There's a heavy safe in his office. So I call my friends, Dave, Dave's not related to us in any way. Dave is a total stranger to the family. I say, Dave, help me move this safe out of the house. I'll give you half of what's inside.
The classic accomplice scenario. Dave agrees.
We do the crime. We get caught red-handed. We are standing in front of the judge, side by side. I, the son, get to walk away because of Article 332.
Correct. You are exempt from criminal liability. You'll probably get sued by your dad, but you're not going to prison.
So, what happens to Dave?
Dave goes to prison.
Wait, hold on. Dave was just the helper, the muscle. I was the mastermind. I was the one who planned it. If the crime itself isn't criminally punishable for me, how can it be punishable for him?
That is the logical trap that many people fall into. But the source is explicit, and the courts have been very clear on this. A stranger cooperating with the son of the offended party and stealing the latter's money is criminally liable, even if the son is exempt.
That feels incredibly, fundamentally unfair to Dave. I mean, okay, he shouldn't be stealing, but he's getting punished for the exact same act that I am walking away from scot-free.
It feels unfair if you look at the act, but the Supreme Court views Article 332 as a personal privilege. It's not an exemption for the crime, it's an exemption for the person.
It's like a diplomatic immunity passport that only I can use.
That is the perfect analogy. The son holds the passport because of his blood relationship and shared household. Dave is just a guy stealing a safe. He has no passport, he has no special relationship to hide behind.
So the moral of the story is, if your friend asks you to help him borrow something from his parents' house,
run away. Run far, far away. Do not get involved. You will be the fall guy. The son will go home to a very awkward Thanksgiving dinner, and you will go to Bilibid.
that is brutal.
Yeah.
But it really, really drives home the point of this entire deep dive. This law isn't about the property. It isn't about the act of stealing. It is entirely 100% about the relationship.
It is. It's all about the law drawing a line in the sand and defining the boundaries of where the state stops and the family begins. It's the law saying there are some doors we just don't want to open.
So let's wrap this up with a magic formula. If you are listening to this and trying to keep it all straight in your head, to qualify for the family exemption, you need 3 things to align perfectly.
Right. First, you need the right relationship. You have to be a spouse or partner, a direct ascendant or descendant, including step and adopted relatives, or a sibling or in-law who is living with the victim. If you're a cousin, an aunt, or a brother who lives across town, you're out.
Check. Second, you need the right crime.
It has to be theft, estafa, or malicious mischief. No robbery, no violence, no intimidation, no falsification of public documents. And for goodness sake, avoid using fire if you don't want a prosecutor to try and charge you with arson.
Check. And third, you need to understand the right liability.
You are exempt from criminal liability, which means no prison time, but you are still fully on the hook for civil liability, which means you can be sued and forced to pay back every last cent.
It is a very specific needle to thread. It's not a blanket free pass for crime. It's a redirection from criminal court to civil court.
Exactly. It's the law's way of saying guilty, but it's complicated, so you all sort out the money yourself.
You know, before we sign off, I just keep coming back to that one concept from the beginning, the co-ownership of common law spouses. The idea that because you live together and work together, the law sees you as an economic partnership.
It's a really powerful legal fiction, isn't it?
It really is. And it makes you wonder if the penal code is willing to essentially say that domestic partners are business partners to avoid sending them to jail for theft. What does that say about how we value domestic labor in general?
That is a profound question. Usually, society and even other parts of the law struggles to put a dollar value on keeping a home or raising kids. It's often seen as non-economic women's work or just a duty.
Right.
But here in this corner of the criminal code, the law essentially says, no, your contribution to this household is so real, so tangible, that it grants you a co-ownership stake in everything in it. You've earned a piece of this.
It's almost like the criminal law gives more respect and economic validation to that domestic partnership than some other parts of society do.
It's an unintended validation, perhaps, a byproduct of trying to keep families out of jail, but it is a very real one, written right there in the case law.
Something to think about next time you're arguing with your partner over who paid for dinner. You might be co-owners of that meal.
Indeed. It's all partnership property.
This has been a fascinating look into the weird and frankly troubling world of Article 332. It's a reminder that the law is full of these little pockets of exception that tell us a lot about what society values. In this case, the privacy of the family, for better or worse, or the punishment of the thief.
Well said.
Thank you for guiding us through the legalese. And to our listeners, keep your suitcases safe, check your local arson laws, and maybe, just maybe, don't steal from your relatives, even if you think you can get away with it.
Sound advice for a happier life.
Thanks for diving deep with us. We'll see you next time.
Welcome to the debate. Today, we're opening the front door, walking into the living room, and asking a question that frankly makes a lot of people uncomfortable. At what point does a family dispute become a crime? We're dissecting Article 332 of the Revised Penal Code of the Philippines. It's a provision that effectively looks at a theft or a swindle and tells the police, stop, you have no power here.
It is a get-out-of-jail-free card, quite literally. I mean, we're talking about a legal concept known as absolutory cause. For the non-lawyers listening, this is a fascinating, and I'd argue disturbing, gray area. The law admits you committed a crime. The law admits you are guilty. But the law refuses to punish you because of whose blood runs in your veins.
Well, that's a provocative way to frame it. Though I would frame it differently. It's not about ignoring guilt. It's a recognition by the state that certain disputes are best settled outside the cold, punitive walls of a penitentiary. So the central question we're debating is this. Is the exemption from criminal liability for property crimes among family members a necessary preservation of the domestic sanctuary? Or does it create a dangerous zone of impunity for financial abuse within the household?
To see why this matters, and to understand the real-world stakes, we have to look at the case of People versus Alvarez. This isn't a hypothetical we made up. It's a real case that reached the Supreme Court. You have a stepfather and a stepson. Tensions are high, as they, often are in blended families. They get into a massive argument. The stepfather, in a fit of rage, grabs the stepson's suitcase, drags it out to the orchard, and sets it on fire.
Which is, by definition, malicious mischief. He destroyed property.
Exactly. He destroyed it. The suitcase is ash. The stepson wanted justice. He wanted to prosecute. He filed a complaint. But the Supreme Court said no. They applied Article 332. Because of the relationship, the stepfather was exempt from criminal liability. The court essentially told the stepson, this is a family matter. Deal with it at the dinner table, not in a prison cell. And that, to me, signals a massive gap in our justice system.
I see why you think that, but let me give you a different perspective. That ruling is the cornerstone of my position. The state should not be the referee of every domestic tantrum. I mean, if we allow criminal prosecution for every burned suitcase or every misappropriated allowance or every dispute over who owns the TV, we're essentially inviting the police into our living rooms to mediate emotional outbursts. My stance is that Article 332 rightfully identifies that specific relationships, spouses, parents, children, operate on a different frequency than the rest of society. Article 332 isn't about ignoring the crime. It's about restricting the state's power to destroy a family over property.
Or it's about the state refusing to protect the vulnerable members of a family from the predatory ones. I'm sorry, but I just don't buy that family harmony should override basic justice. When you tell a stepfather he can burn his son's belongings without fear of arrest, you aren't preserving a family, you are enabling a bully. But let's lay out our positions clearly before we dissect the statute further.
Agreed. My position is rooted in the preservation of the domestic sphere. Article 332 of the Revised Penal Code rightfully identifies specific relationships, spouses, ascendants, descendants, and relatives by affinity in the same line. It says that for nonviolent crimes like theft, swindling, which we know as estafa, and malicious mischief, the intrusion of criminal law does more harm than good. The law views these individuals as effectively co-owners of a shared economy or patrimony. If a father takes cash from his son's wallet to pay a bill, is that truly theft in the same way a stranger picking a pocket is? The law suggests it isn't.
I come at it from a different way. While the sentiment of family unity is nice, the application is dangerous. My position is that Article 332 is an antiquated relic that is overly broad. It leaves family members vulnerable to fraud and theft without the strongest deterrent we have, the threat of imprisonment. You mentioned theft and malicious mischief, but the inclusion of estafa, swindling, is where I draw the line. Estafa implies deceit, it implies machinations, it's not just borrowing the car without asking, it's conning your grandmother out of her pension. By removing criminal liability, we are effectively telling the victim that their rights matter less than the idea of the family.
That is a compelling argument. But have you considered the alternative? Do we really want to see a mother imprisoned because she used her daughter's credit card without permission to buy groceries? That is the path you're suggesting. If we remove this exemption, we turn the justice system into a weapon for family feuds. Imagine a teenager angry at their mother for taking their phone or using their allowance money. Do we want that teenager to be able to file a theft charge? Do we want mothers dragged away in handcuffs because of a dispute over household finances? Article 332 prevents the criminalization of the messy, complex economic reality of a household.
If she used the card to buy groceries, no one is calling the cops. But if she used it to gamble away the daughter's tuition, yes, I might want to see some accountability. And that is the problem. The law doesn't distinguish between messy household economics and calculated predation. But let's dig into the details. Let's talk about who exactly gets this free pass.
The law is specific. It covers spouses, ascendants, descendants, and relatives by affinity in the same line. And to your earlier point about the Alvarez case, the law recognizes the reality of modern families. The court included stepfathers as ascendants by affinity. It implies that the relationship between a step-parent and a stepchild should be accorded the same sanctity as a biological one.
Sanctity or protectionism?
Sanctity. Even adopted children are included under the term descendants, as noted by legal commentators like Guevara. The law is trying to mirror the social reality that these people function as a single economic unit. Even in People versus Constantino, the Court of Appeals went so far as to include a concubine or paramour within the term spouse for the purpose of this exemption.
Which is fascinating considering Philippine law is usually so strict about legal marriage and preserving the legitimate line.
It is, but the rationale in Constantino was practical. The court recognized that common law spouses are de facto co-owners of the property they acquire through their work. If they are building a life together, charging one with theft against the other is absurd because the property is arguably shared. It acknowledges that the bond of living together and sharing a life creates a unique property dynamic, regardless of the marriage license.
That works for spouses, maybe. I can concede that spouses share a wallet. But let's look at the collateral relatives. This is where the shared household rationale starts to crumble for me. The law exempts brothers, sisters, brothers-in-law, and sisters-in-law, but only if they are living together.
Correct. That is the stipulation in the third paragraph of Article 332.
This was highlighted in People versus Navas. You had a brother-in-law who was given money specifically to buy plumbing fixtures for the house. He took the money, he didn't buy the fixtures, and he kept it. He misappropriated it. A clear case of estafa. But because he was living in the house of the offended party at the time, sleeping in the guest room or on the couch, the court said exempt.
Because they shared a roof. That is the crucial distinction the law makes.
But that's absurd. I mean, think about the logic there. If that brother-in-law had lived next door, he would be a convict. He would be in jail. Because he crashes on your sofa, he has a license to swindle? This suggests the law isn't about preserving the bloodline or the family name, but is based on mere physical proximity. It treats the house like a diplomatic embassy where the laws of the Philippines don't apply to the people sleeping there.
I'm not convinced by that line of reasoning because living together implies a shared domestic life. It isn't just proximity, it is commingling. When you live with your brother-in-law, you eat the same rice, you use the same electricity, you likely borrow money back and forth constantly. The lines between mine and yours naturally blur. The law is simply acknowledging that reality. If you prosecute a brother-in-law living in your house, you aren't just punishing a crime, you are evicting a family member and destroying the household dynamic permanently. The law says, handle this civilly, kick him out, sue him, but don't ask the state to lock him up.
But the blurring of lines is exactly where the abuse happens. That's where the predator thrives. A brother-in-law who knows the law can move in, gain trust, swindle the family savings, and walk away with a smirk because he knows Article 332 protects him. He knows he can steal the plumbing money, the grocery money, maybe even the jewelry. And as long as his toothbrush is in your bathroom, he's safe from the police.
He is safe from the police, but not from the courts entirely. But before we get to the civil remedy, I want to address the issue of intent. You characterize it as predation. The law characterizes it as a dispute.
And speaking of characterization, let's talk about the stranger exception. This is the last paragraph of Article 332, and it exposes the unequal justice perfectly.
The exemption established by this article shall not be applicable to strangers participating in the commission of the crime. It seems straightforward enough.
He doesn't walk free. He is still civilly liable. We have to be precise.
He walks free of handcuffs. The mastermind, the son who plotted against his own father, gets an absolutory cause. The accomplice, who has no emotional bond to the victim and arguably owes them less loyalty, takes the fall. How is that justice? It proves that the law's intent is strictly personal to the relationship. The crime of theft still exists. It hasn't been erased. If the crime didn't exist, the stranger couldn't be convicted of participating in it. The law is saying the act is criminal, but the penalty is waived for the son solely because of the blood tie. The stranger has no such tie, so he faces the full force of the law. It underscores that this is a privilege of relationship, not a justification of the act.
It underscores that the law plays favorites. It punishes the hands that committed the crime but protects the brain that planned it, provided the brain shares DNA with the victim. It suggests that the family is a mini kingdom, where the king, the father, or the prince, the son, operates under different rules than the peasants, the strangers. It creates a moral hazard where a family member can effectively say, "I'll do the stealing, you just drive the car," knowing they are immune.
That is a harsh characterization. I would argue it reflects a moral hierarchy where we value the chance for family reconciliation over state retribution. If the son goes to jail, the relationship with the father is severed forever. You cannot undo a prison sentence. If he stays out, perhaps there's a path to forgiveness. The stranger has no relationship to preserve. The state has no interest in reconciling a thief with his victim, unless they are father and son.
Forgiveness is cheaper than restitution, I suppose. But let's move to the nature of the crimes themselves. You mentioned earlier that this applies to theft, estafa, and malicious mischief. But it does not apply to robbery.
Correct, and that distinction is vital. It answers your earlier concern about protecting the vulnerable. The law draws a hard line at violence.
The distinction between theft and robbery in the revised penal code is largely about the use of violence or intimidation against persons or force upon things.
Exactly. If that stepson in People v. Alvarez had pointed a gun at his stepfather and demanded the suitcase, Article 332 would not apply. That would be robbery. If a son breaks a window to enter the father's room, force upon things, that enters the realm of robbery in an inhabited house, and the exemption falls away. The moment physical safety is threatened, the family immunity evaporates. The state steps in immediately.
But you are defining safety purely in physical terms. I'm arguing that financial violence can be just as devastating as physical violence.
But they are categorically different in the eyes of the law.
Are they? Look at estafa, Article 315. It involves deceit, false pretenses, fraudulent machinations. It is a calculated violation of trust. Let's look at the provision regarding widows. The law exempts a widowed spouse regarding property belonging to the deceased spouse. Imagine a situation where a father dies. He leaves children from a first marriage. The second wife, the stepmother, immediately starts hiding assets. She falsifies documents to transfer bank accounts to her name. She hides the family jewelry. This is estafa. She is swindling the children out of their inheritance.
That is a very common scenario in probate disputes, unfortunately.
It destroys the children's future. It wipes out education funds, medical savings. It ruins lives. Yet because no one was punched in the face, the law says no criminal liability. The police can't touch her. You call that preserving the family? That destroys the family just as effectively as a gun.
Actually, that specific provision protects the widow precisely because inheritance is so volatile. We all know how ugly probate can get. Ownership is often disputed until the estate is settled. If we allow criminal prosecution there, we are weaponizing the penal code during a time of grief. Every time a stepmom misplaces a watch, the stepkids will be calling the police, charging her with theft. The remedy is civil. Go to probate court, settle the estate. Don't put the grieving widow in handcuffs because the kids are suspicious.
But if she stole it, if she acted with malice and deceit, she belongs in handcuffs. You keep coming back to, the remedy is civil. Sue them. Let's be real about what that means in the Philippines.
Article 100 is clear. Every person criminally liable is also civilly liable. And Article 332 explicitly states civil liability remains.
It is a safety net full of holes. In the Philippines, as in many places, a civil judgment is often just a piece of paper. If a brother-in-law swindles the family savings and spends it on gambling or drugs, and you sue him, you might win. The court says he owes you 1 million pesos. But if he has no money, if he's broke, you get nothing. You can't garnish wages that don't exist.
That is a risk in any financial dispute, criminal or civil. Insolvency is not a crime.
But in a criminal case, the threat of prison forces restitution. People miraculously find the money when the alternative is bilibid prison. They borrow from other relatives, they sell assets. By removing the criminal consequence, Article 332 removes the leverage. It effectively legalizes theft for the indigent relative. If they steal it and spend it, there is literally nothing you can do.
And I'm not convinced that imprisonment is the correct solution for insolvency. Criminalizing these acts within the family effectively criminalizes poverty and family strife. If you imprison the father for spending the son's money, you strip the family of a breadwinner. You brand him a felon. You ensure he can never pay back the money because he cannot work in prison. It creates a cycle of destruction. The state aims to avoid fracturing the family permanently.
But the family is already fractured. That's what I'm saying. The theft fractured the family. The swindling fractured the family. The burning of the suitcase in the orchard fractured the family. The law is just closing its eyes and pretending the cracks aren't there.
The law acknowledges the cracks, but refuses to use a sledgehammer to fix them. It acknowledges that humans are fallible, especially within the complex web of family dynamics. We argue, we borrow without asking, we damage property in anger. These are human feelings. The law says that not every wrong requires a prison cell to right.
That sounds poetic, but let's look at the concerns of the victim. The law presupposes that the victim wants to preserve the family unit. But what if the victim is the one initiating the complaint? In Alvarez, the stepson wanted to prosecute. He filed the case. The state stepped in and said, no, you can't prosecute him even if you want to. The state is overruling the victim's desire for justice to preserve a family that the victim clearly feels has been violated.
Because the state has an interest in the institution of the family that transcends the individual's momentary anger. Emotions run high in domestic disputes. A son might want to jail his father on Tuesday and regret it deeply on Friday. Article 332 acts as a cooling-off mechanism permanently. It says, you cannot ring this bell.
It says you cannot access justice. It says your rights as a victim are secondary to the state's desire to keep its arrest statistics down and keep the family image intact.
It says you must access a different kind of justice, civil justice, restorative justice perhaps. It forces the family to sit down and talk, rather than hiring lawyers to destroy each other.
Let's briefly touch on the scope again because I think it highlights the arbitrariness. We mentioned in-laws, but notice who is excluded. The law lists spouses, ascendants, descendants, brothers, sisters, brothers-in-law, sisters-in-law. Who is missing? Uncles, aunts, cousins.
They are not included? That is correct.
Exactly. If my cousin, who has lived with me since birth, steals my watch, he goes to jail. If my brother-in-law, whom I met 2 years ago and who is crashing on my couch, steals my watch, he is exempt. Both are relatives. Both live in my house. Why the distinction?
The law has to draw a line somewhere. It focuses on the nuclear family and the direct line of affinity.
It feels arbitrary. It feels like the legislator just stopped typing at a certain point. It creates unequal protection for victims based on a flowchart of genealogy.
It prioritizes the closest bonds, the bonds where property is most likely to be confused or commingled. I would argue that cousins generally maintain more separate economies than brothers-in-law living under the same roof. The law targets the relationships where the shared patrimony argument is strongest.
I think that's a generalization that doesn't hold up in our culture, where extended families often function as massive single units. But fair enough, the law draws a line. The problem is that the line leaves so many victims on the wrong side of it.
And yet, this line has held for almost a century. The revised penal code was enacted in 1930. Article 332 has survived amendment after amendment. It has survived because, despite your objections, there is a deep-seated cultural belief in this country that blood is thicker than water and certainly thicker than the penal code.
Or it has survived because the people making the laws, the patriarchs of these families, benefit from the immunity. It is a shield for the head of the household as much as it is for the wayward son. It allows the powerful in the family to mismanage funds without consequence.
That is a cynical view. I see it as a shield for the home itself. It prevents the state from turning every household into a potential crime scene.
Well, as we wrap up, I think we have exposed the core tension here. While the intention of Article 332 is to prevent state overreach into the private sanctuary of the home, the effect is chilling. It effectively legalizes theft and swindling among relatives, provided you are close enough on the family tree. It leaves victims with expensive, slow, and often futile civil remedies. The peace it preserves is often the peace of the oppressor, silencing the victim by removing their ability to call for help from the police.
And I maintain that Article 332 reflects a necessary moral hierarchy. It places family unity above cold property rights. It acknowledges that the machinery of criminal justice is a blunt instrument, ill-suited for the delicate, messy, and emotional reality of family life. It protects us from becoming a society where children send their parents to prison over money. It forces us to resolve our internal disputes internally, however difficult that may be.
Which brings us to the final question for our listeners to chew on.
Indeed. Does this absolutory cause actually protect the family unit?
Or does it merely protect the black sheep of the family at everyone else's expense?
That is for you to decide. Thank you for listening to the debate.